It's all terribly embarrassing. You may wonder, given that the words human fertilization and embryology appeared so often in that, why I'm talking about terminal sedation. You may still be wondering by the time I'm finished. Thank you, Fiona, for that introduction, and I would like to thank the organisers from all the universities associated with this conference for putting this together, and more importantly, from my point of view, for giving me the opportunity of visiting Brisbane. I did spend an afternoon in Brisbane some years ago, so I feel very well qualified to find my way around. But it's a real pleasure to be here, and I am going to take a few days at the end of this meeting and actually find out a little bit more about the cities, which looks lovely so far. I'd also honestly like to congratulate the organising committee and those who administered. The administrative staff have been wonderful, and actually, unlike British Airways, they made my travel here very easy. Some of you may know my luggage took 40 hours longer than I did to get here, which was all courtesy of British Airways. It was nothing to do with Qantas. But I can honestly say as well that now that I've been at the conference, I have attended over the years very many conferences, as you might expect when you get to my age. And I can honestly say that yesterday was one of the most enjoyable days I've ever spent at a conference. Not only were the plenary sessions outstanding, but the groups that I went to, the presentations in the small groups were also extremely thoughtful, very interesting, and extremely well presented, which leaves me in a rather difficult position this morning, because the bar has obviously been set very high. I should also say that I'm delighted to see so many of you made it after the dinner in a state of perhaps mild sedation, but certainly not terminal sedation, it would appear. Being a lawyer, I have to start with a disclaimer, because it's in the rules. You can't talk otherwise. And the disclaimer is there will be no PowerPoint. Thank you. Oh, good. Oh, good. I have my young colleagues at the University of Glasgow find this vastly amusing that I don't use PowerPoint, and of course they all know how to do it. I heard a couple of very elegant explanations yesterday about why PowerPoint is not a good idea. I just wish I'd thought of them first. The simple truth in my case is that I'm a bit of a technophobe. I'm too old to change, and I wouldn't know how to make a PowerPoint presentation anyway, so I'm afraid you'll have to listen to me. The benefit from my point of view is that when the PowerPoints are up and the lights are down, I can't tell if you're asleep. But I can this morning, so feel free if at any stage you want to. One of the things that struck me from yesterday's sessions, and in particular I think the first session, was the allusion to the fact that lawyers and healthcare professionals tend to think in different ways about issues. We approach things from a slightly different perspective in some situations. And I think what I have to say this morning, you may find, is that is evidence of that writ large. Because apart from anything else, while lawyers, and especially academic lawyers, have the opportunity to sit back and look at the big picture, for those at the bedside, this is not nearly so easy. And so if anything that I say makes people who are engaged in terminal sedation or any palliative care feel a little bit uncomfortable, I apologize in advance for that. But like Jocelyn was discussing yesterday, I think it's very important that we look at the big picture, even if on the day that's rather difficult to hold on to. So forgive me if I say anything that make you feel a little bit uncomfortable. The first task of any lawyer, obviously, is to define their terms. And when I started doing some research on terminal sedation, I discovered, to my amazement, that there are, in fact, a huge variety of terms that are used for the practice that in my title is called terminal sedation. For example, I managed to find references to sedation pure and simple, terminal sedation, sedation for intractable distress in the imminently dying, end-of-life sedation, total sedation, sedation in the terminal or final stages of life, controlled sedation, palliative sedation therapy, and continuous deep sedation. As you're aware, probably the two most common of these terms that are used are palliative sedation and terminal sedation. Van Delden has argued that we should stick with the concept of terminal sedation because it unequivocally is, because all of these terms have a normative content, they all say something slightly different about what the sedation is for or what it's about. In his view, we should stick with terminal sedation, as I will, because there is an implication in that concept that the timing of death may be influenced. Now, I'll come back to that because I know some people might disagree with that. We should also bear in mind that there are a number of medical decisions at the end of life which, although they are overtly designed to treat or to palliate, can shorten survival. For example, it's been claimed that in 2010, an end-of-life decision was taken in almost 58% of all deaths. Terminal sedation becomes an option when the patient's symptoms are refractory, and I'm sure most of you in the audience know what that means, but if I can just, for those of you who are not healthcare professionals, the best definition I could find of that is that a symptom is refractory when the clinician perceives that further invasive or non-invasive interventions are first, incapable of providing adequate relief, second, associated with excessive and intolerable acute or chronic morbidity, and or third, unlikely to provide relief within a tolerable time frame. In these circumstances, terminal sedation may be considered as the only available tool to relieve the distress and the pain of the patient concerned. One thing that I also found interesting was that, according to the literature, the use of terminal sedation is increasing. And one commentator noted that dying after having been continuously sedated for some time is fast becoming one of the standard ways of dying. So this is obviously a very important topic and by no means on the fringes of the debates about end of life. I'm going to have to refer to my notes here. This is actually the one point at which it would have been useful to have a PowerPoint slide or two, because I have some figures that I would like to share with you. I can deliver these to Ben and Lindy, and I guess they can be put on the website or somewhere, along with the sources from which I found them, if any of you want to follow them up. I should also say, not apologetically, that much of what I am going to talk about, it has a European bias to it, rather than a North American or an Australian one, and I'd be very happy to hear from people representing non-European countries as to whether or not the experience reflected here rings any bells with the experience that you're used to. The figures I have also mostly relate to Belgium, the Netherlands, and the United Kingdom, and I know we have experts from all of these countries in the audience, and again, if you want to update or discuss these figures, I'd be very happy to hear from you. So I will ensure that these figures are made available to you. Clive Seal, who you will know is a frequent commentator in this area, has estimated that the use of what he would call continuous deep sedation in the Netherlands between 2000 and 2005 rose from being involved in 5.6% of all deaths to 7.1%. In Belgium, the rates rose from 8.2% of deaths in 2002 to 14.5% in 2007. According to his findings, continuous deep sedation or terminal sedation in the United Kingdom is more commonly used in patients who are younger or are dying of cancer. Further research showed that in Flanders in Belgium in 2007, the incidence was estimated to be 15% of all deaths. In the Netherlands in 2005, this was 8%. And in the UK in 2008, its prevalence was in 17% of all deaths. They also found that terminal sedation lasted in most cases for 1 week or less in all countries, and in both settings, that is in hospital or at home. They speculate that the variation in the rates of use from 5% up to 17% in the UK may in fact be a result of the differences in the laws regarding end of life in these countries. Where assisted dying is legally permissible, they suggest, physicians and patients can, and the quotes are theirs, choose between euthanasia and continuous deep sedation until death. Whereas in the United Kingdom, where there is no legalized assisted dying, the speculation is that the high rate may be because terminal sedation is perceived to be the only legal last resort option for a physician treating a terminal patient with refractory symptoms. As in so many situations at the end of life, the Dutch have played a leading role, and this is no less obvious in the case of terminal sedation. For example, in 2005, the Dutch drew up national guidelines which were amended in 2009. The medical profession was encouraged by the government to develop these guidelines, which require evidence both of refractory symptoms and a life expectancy of less than 2 weeks. Guidelines developed by the European Association for Palliative Care also endorse the use of terminal sedation, noting that it requires due caution and good clinical practice. In the United States, the American Medical Association adopted guidelines which state that palliative sedation should remain an option of last resort for patients with far advanced terminal disease whose suffering has proven to be refractory to all other measures. While some guidelines do exist then, and there obviously are international guidelines also, one of the first potentially worrying characteristics of the use of terminal sedation is that on comparative analysis, significant differences emerge in the way in which this is used and the indications for its use. Most worryingly, and this may result in from the failure to decide whether or not this is good medicine, there are variations within and between countries in what would initiate the call for terminal sedation and its use. Orentlicher, for example, discovered that patient access to palliative sedation, and this will be in the United States predominantly, may turn on the physician's field of practice or other personal attributes. For example, he notes, doctors in the southern states of the United States are less likely to provide palliative sedation than those in the north, and in fact, even within those boundaries, that may vary within communities. Finally, he notes, and this is a point that I think is significant, that physicians often develop their own practice patterns for idiosyncratic reasons. This would be generally in medicine. And that reality, in this case, will influence the use of palliative sedation. ICEL suggests that palliative sedation is more likely to be reported by doctors who support the legalization of euthanasia or assisted suicide and who are non-religious. This suggests, and I don't suggest for a second this is universal, but it does suggest that in some situations, the decision whether or not to provide palliative sedation may be influenced not simply by the condition of the patient, but by the attitudes of clinicians who are charged with the care of these patients. ICEL would suggest that what we need to do, and I can't draw any conclusions from that, but he suggests that the association between the provision of terminal sedation and doctors' attitudes towards assisted dying, coupled with their religious beliefs, requires a better understanding of the ethical reasoning of doctors who use terminal sedation in particular cases. So sadly, it's possible to conclude, albeit not by no means in all cases, that in some situations where terminal sedation should be concerned solely with the needs of the patient, sometimes they depend to some extent on the preferences of the patient's physician. And this may result in a denial of what I think we can all agree is good medicine. There is nothing inherent in terminal sedation that is in any sense objectionable, except to those who haven't agreed to it, or in circumstances that I'll come on to. So we can say it is good medicine, but we can't necessarily say that it is good medicine that is always supplied to those who are in need of it, and that, I think, is a matter of some concern. I want to refine my terms just a little further now, before getting to the meat of the presentation, and that is that when I discuss terminal sedation for today's purposes, I am discussing specifically terminal sedation without the provision of nutrition, assisted nutrition and hydration. That is because I think unarguably that is probably the most controversial form of terminal sedation, since the deprivation of nutrition and hydration, and particular hydration, seems a different decision from the choice to remove consciousness. It's been reported that terminal sedation without assisted nutrition and hydration occurs in 39% of cases in Belgium and 56 to 80% of cases in the Netherlands. It should also be noted that the Dutch guidelines that I've already referred to state that in the case of terminal sedation, no assisted hydration should be provided unless where the patient is unable or unwilling to take fluids. In other words, if you are unconscious, there should be no provision of assisted nutrition and hydration. Now, some people want to argue that that's really just one decision. This is not exceptional in any sense, that the decision not to provide, the decision to initiate terminal sedation and the decision not to provide assisted nutrition and hydration are merely one and the same decision, because this is the way in which it's done. Now, I think that's a contentious point of view. In practice, it may or may not make a significant difference to how clinicians view this, but in reality, the decision to sedate is truly a decision to palliate. The decision to deprive of nutrition and hydration is a decision which relates more directly than the decision to palliate to the likely lifespan of the person in question. Now, I'm aware that there is some contention about the question of whether or not the failure to provide ANH in fact shortens life or doesn't shorten life. But irrespective of what evidence we can conclude in that, there is nonetheless an issue of principle associated with whether or not we can or should separate out these two decisions, given that there will be an impact, most likely, on the patients concerned. The evidence that I was able to find is that it's believed that in the Netherlands, terminal sedation was believed to have shortened life by more than a week in around 27% of cases. So the fact that in the Netherlands no assisted nutrition and hydration is provided might be a link to the fact that this 27% of cases, life was shortened by more than the period that might have been otherwise expected. Glenys Williams would argue that whereas the goal of administering barbiturates or benzodiazepines to induce sleep to relieve suffering is good and beneficial to the patient, on no interpretation, she argues, can the additional step of withdrawing artificial nutrition and hydration be considered a necessary condition of relieving pain. There is one other question that occurred to me, and I'm sure it's occurred to those of you who are involved in this, and that is the question as to why terminal sedation should be restricted to cases of imminent death. And I will discuss this a little bit more later. If it is indeed designed to alleviate refractory symptoms, then arguably it should be available irrespective of the presumed but not provable expectation of length of life. Commentators have argued that every patient has a right to adequate pain and symptom management, and I think everybody in this room would agree with that. And if terminal sedation is a good way, in limited circumstances, of providing pain and symptom management, then it's difficult to imagine why it should be denied to those whose life expectation is longer than, for example, 2 weeks. In Belgium, for example, access to palliative care is a legal right of all patients, not only those whose death is imminent. And again, if this is good medicine and this is palliation in its purest form, then it's difficult to understand why terminal sedation would not be included. And those of you from Belgium may be able to explain to me, perhaps it is in that country. In addition, the exclusion of existential suffering, so-called, and I had a very interesting paper on that yesterday, in some guidelines, not in all guidelines, but in some guidelines, existential suffering is precluded as a trigger for terminal sedation, needs, I think, to be questioned. For those who are suffering, and Malcolm Palmer, he's somewhere over there, and I spoke about this yesterday in one of the small sessions, but for those who are suffering, albeit perhaps not physically, allowing them to die a good death and a death that is palliated, that is easy for them, may require bringing existential suffering within the scope of medical action. Now, I am aware, and especially what Malcolm was talking about yesterday, that there is an argument that says that existential suffering is not a medical condition and that doctors should only be involving themselves with medical conditions. I suspect, however, that's drawing too fine a line, not least because for those patients who are also in pain, one of the reasons for providing the palliation is to avoid the distress that goes with the pain, the nausea, the sleeplessness, and all the other symptoms that people might be suffering, some of which are arguably existential as well as pathological or purely clinical. The interesting thing from my point of view is that existing professional guidelines actually contradict themselves on the question of whether or not existential suffering should be included. And I would agree with those commentators who suggest that we should think again about the exclusion of this group of patients. I'm going to return to that as well because it has consequences for the ethical and legal debate surrounding terminal sedation. So what I would like to do now is briefly, Fiona has a bell, and those of you who remember my attempt to keep myself to 4 minutes yesterday, although I think Lindy sold me short, just like Jocelyn, but I will attempt to, I'm going to be quite brief because I hope that there will be plenty of time for discussion, and by my reckoning I've got about 15 minutes to go, something like that, okay? You'll be glad to hear it's nearly over. Okay, so what I want to do first of all is look at what are the ethical justifications broadly used to justify the use of terminal sedation. Usually the ethical principles that are appealed to are the principles of double effect, the principle of autonomy, and the principle of proportionality. Now, if we accept the point that Williams made earlier about the fact about there being no need to combine terminal sedation with the removal of or withholding of assisted nutrition and hydration, then the proportionality point can be answered. In other words, the withholding of the ANH would be disproportionate to the aim, which is the relief of pain and other refractory symptoms. So in a sense, we can perhaps leave that one aside. I should also say that I'm not going to address autonomy until I get to the legal bit, for reasons which I hope will become obvious. So the real justification that I'm going to consider then is the use of the principle of double effect. Double effect is something that I think we're all familiar with as a concept. It's actually a very complicated concept, and so I want briefly just to repeat what are the requirements for double effect to be appropriately used as a justification. The principle states that when a contemplated action, in this case sedation, has a good, in this case relief of suffering, and a bad, which would be the possible foreshortening of life, effect. So if it's got a good effect and a bad effect, it is permissible, the action is permissible if first, the action is either morally good or is morally neutral. Second, the foreseen yet undesired untoward result, that is foreshortening life, is not directly intended. Third, the good effect is not a direct result of the foreseen untoward effect. Fourth, the good effect is proportionate to the untoward effect. And fifth, there is no other way to achieve the desired end without the untoward effect happening. So it's quite a complicated, multi-layered principle, slightly more complicated than is sometimes presented. The principle then is broadly concerned with intention and causation. And it's generally used also to distinguish between legitimate and illegitimate practices, in this case within medicine. Most specifically, it's used to promote an alleged difference between terminal sedation and other forms of assisted dying, such as voluntary euthanasia and assisted suicide. And this distinction is drawn on the basis that there is a difference, and the difference is that in the case of voluntary euthanasia or assisted suicide, the intention is the death of the patient. In the case of terminal sedation, the intention is simply to relieve pain, and it is not directly concerned with attempting to kill the patient. However, arguably even a cursory consideration will show that inferring or identifying intention from declared motives is highly problematic. In other words, we may say that we are not intending the death of a patient, but in fact it may be that we are, however subliminally, at least expecting that result and may even desire that result. In fact, some studies have shown that mixed motives can and do arise in the practice of terminal sedation. For example, De Greff and Dean have pointed out that the use of sedation for the relief of symptoms at the end of life is, they argue, open to abuse. And they point to data from several countries, and I'll make sure you've got this reference as well, that indicate that administration of sedating medication ostensibly to relieve distress, but with the manifest intention of hastening death, is, in their view, commonplace. The use of double effect, if they're right, then, is inappropriate in these circumstances, since the intention would appear to be as much to bring about death as it is to alleviate suffering. But even if the intention is purely the alleviation of suffering, you can still question whether or not double effect is appropriate where terminal sedation is combined with the failure to provide ANH. Williams would argue, in fact, that the principle is wholly inapplicable in this situation, because while it can be argued that sedation does ease pain, and that can be justified under the principle of double effect, withdrawing nutrition and hydration or withholding it does nothing to relieve the patient's suffering, and the inevitability of death following its withholding or withdrawal means that it does not satisfy all the conditions of the principle of double effect. Soren Holm, a philosopher with whom many of you will be familiar, I'm sure, argues, following that conclusion, that in some situations, the one I'm talking about, where terminal sedation is combined with the withholding of assisted nutrition and hydration, looks, he says, very much like a slow form of euthanasia. The patient, he says, is put in a state where she is unable to take water and food, hydration and nutrition is not provided, and the person will eventually die from dehydration if the underlying disease doesn't kill them first. What this means, he says, is that where patients' life expectancy is indeed very short, then it is likely that the withholding of nutrition and hydration will have no impact on the time at which they die. However, he points out, it is rare that we can actually predict with certainty the length of life that people may have left, although I'm sure it's possible in some cases. There will always therefore be the possibility that the removal of or withholding of assisted nutrition and hydration will contribute to the death of the patient, and in which case it would not be covered by the principle of double effect, and it would amount to a kind of form of assisted dying. In the case under consideration then, that's the terminal sedation case, it would seem that this principle doesn't in fact provide sufficient justification on its own to render the practice ethically acceptable, even if it is clinically optimal practice. That suggests to me that one of the things that we might usefully do is to think again about how we justify the practice of terminal sedation. I'm not suggesting it's a bad thing, and I'm not suggesting it's wrong, and I'm not suggesting that it's not appropriate in many cases. But it is, again, as Jocelyn said yesterday, in the view at least of a lawyer, extremely important that the values and the principles that underpin our actions are fully explored and can be justified on clear, unequivocal, sound ethical principles. My suggestion at the moment is that there are no such principles, that the principles that we currently use to justify the use of terminal sedation are not fit for purpose in these circumstances. That's not to say we should stop doing terminal sedation, it's rather to say that we should think again, perhaps in a more nuanced way, about how we might go about justifying its use at an ethical level as opposed to a clinical level. That will have consequences though, and I'll conclude on this point later. That will have consequences, I would suggest, for the way in which we view all end-of-life decisions. If we actually have to elucidate and elaborate a clear, principled set of ethical considerations, then we have to ask what really is the difference between this practice and other end-of-life practices, and I say I'll come back to that. The legal considerations, I think, can be covered fairly briefly, but they are, if anything, slightly more contentious. It's generally accepted in law that any intervention, whether or not medically supported or clinically indicated, requires that the patient provides a valid consent. Now, without this valid consent, criminal charges may be brought of assault or worse, and that might attach to the act in question. Now, consent is said to be the legal vehicle by which we reflect autonomy. In other words, autonomy is an ethical concept, but for the law, the appropriate concept is the law of consent. Now, some of you may know I would actually dispute that the consent rules are able to protect autonomy, but taking for the moment the position that that is what the law of consent is supposed to do, then we have to ask what is the practice in terms of terminal sedation of patients. In other words, without the consent of the patient, technically any medical intervention could be an assault, and if the outcome of the medical intervention is the death of the patient, it could lead to more serious charges than that. So you might think, and I realize there may be circumstances where it's not possible to discuss this with patients, but where it is possible to discuss the use of terminal sedation, particularly without the provision of ANH, then you would imagine that this would be one clear case in which the law, however inadequate in other areas, would be an extremely effective tool for ensuring that the autonomous decisions of patients are carried out and respected. In other words, here is a classic situation where the only thing that separates medical action from a criminal charge or civil liability is the consent of the patient. So here is the classic situation in which consent is at its most important. Perhaps surprisingly, though, the Dutch guidelines that I referred to earlier seem to be a little bit more equivocal on the question of patient consent. For example, some commentators have noted that whereas being aware of the preferences and wishes of the patient and the family can arguably facilitate the decision to start terminal sedation, this may sometimes complicate the decision. So consent can complicate things, presumably for healthcare providers, probably not for the patients. The guidelines, in fact, are clear that this is a medical decision, and where the preferences of patients and families and the patient's life expectancy are weighed against the severity of refractory symptoms, then it is permissible to take the clinical option and the consent of the patient and the views of their proxy decision makers are not the primary decision-making tool. That being said, in 96% of cases in the Netherlands, as far as I can tell, consent was sought and obtained. But on a comparative basis, it's been suggested that some studies show that in significant percentage of cases, consent from the patient was not sought and therefore was not obtained. Now, as I've said, that places clinicians in a somewhat dubious legal position because it is consent that protects them from allegations of a criminal or a civil nature. The simple example is anybody else performing surgery would be committing a serious assault. And it is not just the context that it's within healthcare that distinguishes doctors' behaviour from those of myself, for example. It's also the fact that a consent has been obtained to that assault. Now, you'll know, the lawyers in the audience in particular will know, that consent is not a defence, usually, to allegations of assault or of murder. Medicine is a special case in terms of assault because it has to be. The law is being pragmatic here. Naturally, we can't sue doctors every time they operate because that would just be silly. So what the patient's consent does in the medical context is to neutralise an action which might otherwise have been considered to be criminal. So it is extremely important in this context, perhaps more than anywhere else. Now, there's another problem with the question of consent, and that relates to a situation in which, for very good reasons, it's decided that the patient, because of the refractory suffering, is not in a position to be competent to give a consent. In these circumstances, clinicians are generally, by law, allowed to intervene if it's not possible for a person to make a valid decision, sometimes by use of proxy decision makers, and sometimes using the doctrine of necessity, which I'll refer to in a minute. But that does not deny the fact that consent is still necessary, even if it comes from a proxy decision maker, because that also provides the protection to clinicians and protects the autonomy, either at first hand or at second hand, through proxy decision making of the patient, him or herself. Now, I'm very well aware that proxy decision makers don't always get it right, and it is not clear that they always truly represent the views of the patient. So ideally, even although such consent would validate the action, where feasible, this would suggest to me, and I think our medical speakers yesterday morning also touched on this, that we should not hesitate to raise the possibility of the end of someone's life approaching earlier rather than later. In other words, talking to patients is a good thing, and it's not necessarily the case that talking to patients about the fact that they will die is a bad thing. It's not clear that patients don't understand that they're on a terminal path, and again, I think our medical speakers referred to that. So to avoid the problems of proxy decision-making and to avoid the problems of patients being incompetent to make their own decisions, it just makes common sense to me, both for the patient in terms of protecting and respecting autonomy, and also for the protection of the clinicians involved, that healthcare professionals bite what is a very difficult bullet, I appreciate, and start discussing this with patients who may be on that path sooner rather than later. In that way, we can ensure that the good medicine, that is the practice of terminal sedation, is canvassed in advance and is available to patients who might want it. It also allows for the canvassing of the question of whether or not that sedation should be accompanied by assisted nutrition and hydration, which patients can refuse. In other words, some of the potential legal uncertainties and perhaps even some of the ethical uncertainties can be removed, as is often the case in medicine, by simple conversation, discussion, and information sharing. From the physician's perspective, the question then is whether or not their behaviour might be categorised as criminal, even although I think it would be most unusual that doctors would ever be prosecuted. Equally, it might raise a civil liability, which is no less traumatic for the doctors concerned and no less inappropriate for the patients concerned. If we leave aside the question of intention, which I've already discussed, the law takes a particular approach to judging medical behaviour. Certainly, and in civil as well as in criminal cases, certainly in the United Kingdom and I believe in many other jurisdictions, there are a couple of techniques that are used to judge the quality of the behaviour in question. And the first and most obvious one is to ask the question, what would a reasonable doctor have done in these circumstances? And that can provide a shield against allegations of negligence, for example, in some jurisdictions. Where doctors are able to argue that their behaviour is in accordance with a standard practice, then it is sometimes the case that they will escape liability that otherwise they might have incurred. I don't want to go on at great length with that because I've got my 5-minute thing. The other distinction that I think is worth touching on briefly, and it was touched on again and yesterday morning, is the question of whether or not there's a distinction between acts and omissions in this setting. Some people have described this as a distinction without a difference, and certainly, unfortunately, I think it is accepted by courts in most jurisdictions, so that the distinction would be drawn between terminal sedation with no ANH would be an omission, whereas assisted suicide and euthanasia would be an act. The latter is culpable, the former is not. I think that conclusion can be and has been challenged, as Peter Singer did yesterday morning, especially when the death results from the dehydration, or at least is partly results from the dehydration, and is foreseeable, which sometimes in law is taken to imply intent. So there are some situations where if something is so obviously foreseeable that you knew it was going to happen, then that is the equivalent to intending the outcome, in this case, the death. One further defence that has been considered is the defence of necessity. In other words, you act because you have no option but to act in these circumstances. So the patient is suffering so desperately that you have to do something. That may well apply to the element of sedation in the picture that I've drawn, but it is dubious that it also would apply to the withholding of assisted nutrition and hydration. In other words, the good bit, which is the sedation element, you might be able to argue that it's necessary to do that, but it's difficult to argue that it's necessary to deprive the patient of assisted nutrition and hydration. So that doctrine will not apply. So in conclusion, I'm afraid I skipped over that a bit. In conclusion, I think we can say that terminal sedation, particularly where it involves withholding or withdrawal of ANH, is a very complex issue. We can agree that it's good medical practice to sedate patients in these circumstances, but we may struggle to find ethical and legal justifications which ultimately, in the bigger picture, satisfy all of our intuitions and all of our understandings. The fact that terminal sedation seems to be, in some cases at least, dependent on considerations that are as much about clinicians or community values as they are about the needs of particular patients predicts uneven availability, despite, and in some cases perhaps because of, the existence of guidelines. So even if we want to maintain a bright line between terminal sedation without ANH and other assistance in dying, there is one further question. We believe it would appear in most jurisdictions that it is necessary to regulate end-of-life decisions, in particular in respect of euthanasia and assisted suicide. If my analysis has anything of the truth in it, then assisted nutrition and hydration removal in terminal sedation cases is moving slowly towards another end-of-life decision, not dissimilar to those which are reflected in voluntary euthanasia and assisted suicide. In that case, if we regulate the latter two, then I would suggest we need to think about regulating the provision of terminal sedation without assisted nutrition and hydration, but not through clinical guidelines, not through international statements, but, as Jocelyn said yesterday, genuinely through the law. And the reason for that is that we expect, and we have a right to expect, that these practices will be conducted in a principled, fair, accountable, transparent manner, with due attention to justice, with due attention to needs, and with due attention to compassion and conscience. And I would propose, I would suggest that unless the law steps in, at a general level, all that we're going to get is doctors uncertain about their legal position, struggling with making ethical justifications for the practice, patients unsure about what they can expect at the end of their life, and a piecemeal set of law, which will, again, I'm repeating Jocelyn, but I do entirely approve of what she said. If the courts are the sole arbiters if clinicians are the sole arbiters, they are struggling, and they have to struggle because these are very complex issues. If the courts are the sole arbiters, they too will struggle because these are very complex issues. And while courts would be involved where there are legislative framework in interpreting the law itself could encapsulate the values that I think are important, not just for patients, but also for healthcare professionals who are involved in the provision of that care. Thank you.
And that was perfectly timed, so thank you, Sheila.
The bells got me terrified.
I'd like you to join with me in thanking Sheila for a really interesting talk, and we're going to have a round of questions. So if anyone has a question to ask, please approach the microphone. And there's already a scrum. Fantastic.
It's a deluge. Maybe I moved first, I don't know. I was all set to. I obviously approve of what you're saying, even though I find myself conflicted about it for obvious reasons. The real reason that I am so conflicted is that most of the consent giving would be by proxies in the real world that we currently work in. So a paradigm case would be somebody who came in with a terrible illness, ended up on a ventilator. We ended up feeling we had to withdraw treatment, and at that point you do terminally sedate. There's no question that terminal sedation is the normal way to die in an ICU. The consent for that we would normally get from a proxy, but in Australia we've legislated what the role of proxies is, and it excludes giving consent. I mean, I don't know what Ben thinks, but it certainly does not include giving consent on that basis. And I wondered how the Mental Capacity Act in the UK has influenced the way that that's done, and whether that actually serves as a reasonable model as to how we might change legislation here.
Yeah, I think it might actually. The Mental Capacity Act filled some of the loopholes that the law in the UK had, which were very similar to yours. That is, there is no other person who can make a decision for an adult person, even if they're incompetent. And so the mental capacity legislation and the equivalent legislation in Scotland at least attempted to fill those gaps, in part by looking at the interests of the person concerned, the person who is incapable, and allowing people a certain authority. It doesn't, however, answer the intractable question, which is how valid are proxies' decisions in respect of the people they're deciding for. And I've seen some literature that suggests that proxies get it right in about 40% of cases. In other words, that's how they reflect. So, because they're obviously coming at it with a slightly different perspective. But again, and I know this isn't panacea for everything, but again, it does, I think, suggest that those of you in the audience, and I know there are some people here who are activists for talking to patients at an early stage, it does suggest, just as in the case with organ transplantation, the whole procedure goes more easily if you know in advance what the person's wishes are. And that's the closest we're ever going to get to proxies that are accurate for the individual concerned. But I do think the Mental Capacity Act in particular is, I think, a model that would be worth considering, because it does fill in some of those gaps and adds some kind of certainty.
Thank you.
Hi, Sheila. My name is Olaf van Wijk, Adelaide. I would like to challenge the notion, which is very prevalent in society, that there's a difference between existential suffering and physical suffering. If you look at the modern imaging techniques, functional imaging techniques, really the thought processes in the brain, as far as we can see, are very similar. And that's the experience we have. I'm in pain medicine as well. That's the experience we have as well. There isn't that much difference between physical and mental suffering. And although from a spiritual and religious point of view, that's sometimes hard to grasp, I think if you're looking at making laws, it should reflect the reality as we live in.
Yes, I mean, I obviously would agree with that. It seems to me that that some of the attempts to separate out pathological physical suffering from existential suffering were really would not be sustainable if you took the argument further. And in any case, as I say, if we are saying that people who are suffering unbearably at the end of their life, when they're at their most vulnerable, should be or can be given this kind of assistance to have a death that is, if nothing else, not a suffering death, then it makes no sense to separate it out into kinds of suffering, because the suffering is there and the suffering is real, and only the patient can tell you what the suffering amounts to and how much it makes their future unbearable. So I entirely agree with you. I can see why some people would want to separate it, though, because most healthcare professionals are probably more comfortable with physical symptoms. I mean, that's what they're trained to deal with, and only some disciplines are trained perhaps to deal with more existential suffering. But the fact that we are slightly less comfortable with it isn't a good enough reason, I think, for making that artificial distinction. Thank you.
Thanks, Sheila, for the talk. I wondered if I could get you just to unpack your view of the ethics of the ANH association with terminal sedation, particularly as it applies to proportionality and double effect. And as a clinician, I guess our sense of terminal sedation, as you termed it, for persons in a palliative context, often say a person with advanced cancer with refractory symptoms who's thought to be in that last stage of actually actively dying. Our sense would be that most of those people would not be able to eat or drink, or would have less interest in that eating and drinking perhaps would not be beneficial to them. And at least there is some evidence, though obviously contested, that in fact giving a person food and fluid at that stage of life can actually cause more symptoms and therefore cause harm. And I just wondered how you feel that fits into those ethical distinctions you raised before.
Yeah. I mean, as is common, there is a clear distinction between the real world and how we might approach things from a theoretical position, and I take that point. I think the point is that if we are going to be able to justify our practices, then we have to be able to do it from some kind of principled basis. My suggestion was that the double effect principle, which is the commonly used one, is in fact not fit for purpose where you're trying to justify also withholding ANH. You could justify it in any individual patient on the basis that it is harming that patient.
Sure.
That's a justification you always have available to you. Mm-hmm. But as a rule of thumb,
sure,
then you have to find a better justification for withholding ANH, because in theory at least, and sometimes in practice as we've seen, it does contribute to an earlier death for the patient when it's withheld. And it would make a big difference if we accepted the concept of existential suffering was appropriate. Then you're not talking about people who are imminently dying, yes, and you would have to then think again. So my sense is that that the law at the end of life in most countries is a mess. And what we need to do is to say, let's think this again. Let's not draw artificial distinctions. Let's get a clean slate and say, yes, in some cases we are helping patients to die. That's not a bad thing. Rather than trying to come up with convoluted explanations like using double effect, which in any event is a principle I think is quite dubious. So yes, if you are confronted with a patient and it's clear that ANH is causing them distress, fine. Then you have every justification in saying this is not in my patient's interest. But to do it as a matter of routine requires a much more soundly based ethical basis. And as I say, I think leaves doctors vulnerable and other healthcare professionals vulnerable to the law as it currently stands. Okay.
Colleen, and can I ask the questioners to keep their questions short so we can get through you all?
Oh, how can I keep anything short, Fiona? You know that. Sheila, thank you. Wonderful presentation.
Thank you.
I would like to say that the term failure to provide ANH kind of made me go, okay, because that kind of seems to automatically assume a positive neglect or abuse.
Sure.
But apart from that, I'm just thinking we can draw inferences about the effect of ANH on people in terminal sedation, possibly from 3 areas of work. One is Finucane's 30-year Medline search of all trials of peg feeding for people with advanced dementia, where he couldn't find even one study that could demonstrate any positive benefits, and found several studies that showed lots of negative outcomes. The second is Berkey's work and others on the fact that as death approaches, many people will have seen someone who is terminally restless and at the very end becomes calm and euphoric. And it appears from that literature that the human organism is programmed to recognise when death is approaching, to release endorphins that act as a natural analgesic. But if you continue to artificially feed and hydrate, the body doesn't get the signal and doesn't release the endorphins, so you deprive the person of a peaceful death. Combining those two with Linda Ganzini's work on people who voluntarily chose to stop eating and drinking, and their dying was rated by nurses not knowing what she was looking for, higher than people who didn't choose to voluntarily stop eating and drinking. So I think all of those together suggest that withholding or withdrawing artificial nutrition hydration from a terminally ill unconscious patient is not only in the patient's best interests, but may also prevent harm to the patient. And if this is so, would you agree that the doctrine of necessity does apply?
No, I wouldn't agree the doctrine of necessity applies. I do think that the concept of good clinical care applies, and I do think that in some circumstances where decisions are being made in the best interest of a patient, that is a profound and good justification for saying, no, this is going to harm the patient, it's not going to help them. That's absolutely fine. It may not be the case in all such situations, however, so we need a justification that allows us to do this in circumstances where our best guess is that it's going to be against the interests of the patient to proceed. So I don't think this is an issue about necessity in legal terms, but I think it is an issue of a combination of principled approaches and good clinical practice, both of which should live harmoniously with each other, but need to be clear, accountable, and transparent. Okay, thank you.
Thanks very much, Professor McLean. Great talk, and I think your call for regulation and perhaps law bears some consideration. So I'm from Canada, and in a place where we've had really well-established palliative programs in all settings, intersectorally for 20 years, palliative sedation has been really rigorously applied within the setting of expert palliative care provision. Problem for that in a country like Canada is that we're so widely dispersed. It might be that some people don't receive it. Outside of the ICU, in palliative programs, 3 to 4% of people receive palliative sedation, exceedingly different from the statistics you provided for other countries, which is distressing for me as a palliative physician regarding the unequal access to what might be a really important technique for patients. Can you see if there is the possibility of regulation or law that we might get to the point where it might be viewed as almost negligence below the standard of practice if there is unequal access throughout different jurisdictions?
Sorry, the very end, but that might be below standard of care not to provide terminal
yeah, not to offer to. I tell everyone, we use it very infrequently, but I tell every one of my patients just to minimize the risk that they will be living their last weeks thinking that they will have unbearable suffering at the end of life. Yeah. In our rules, it's within the last 5 to 7 days of life that we can provide it, so it is very infrequently used. Yeah. And I'm glad of that, and I think that our practice has been shown to be, exceedingly carefully applied, but just wondering about that huge variability for patients from a justice issue. Yeah.
No, I think it could be. I think you could describe it in that way. If what you have is a platform that starts from the notion that all patients have a fundamental right to the best available palliative care, if the best available palliative care is terminal sedation in their case, then yes, I think it would fall below standards that would be acceptable if it wasn't available to people and wasn't offered to people. But it goes back to the question of consent and authorization for these things. You talk to your patients about it, which means that they're informed in the decision making and they're able to say, I don't want to die that kind of death. That also, just as it happens, provides you with an adequate legal justification for what you're doing. My point is that we need to be saying, A, we need to talk to people about it, B, we need to give them the choice, and C, if this is good medicine, as I think most people would agree it is, then we have to make it available to people when it's appropriate to do so. And that means no variations in availability because doctors don't approve of it or whatever, and no variations in the indications for its use. That's good for everybody. It's good for patients and it's good for healthcare professionals as well. So yes, I don't see any problem with the law setting a standard that says when appropriate good care is available, every patient has a right at least to be offered that option to ease their dying if that's what they choose. So yeah, I think it could be a legal standard.
Thanks.
Thank you. It's a bit like the penalty shootout at the World Cup, isn't it? You wonder whether you're going to be needed before the game ends. We had a patient, a delirious patient, accidentally get out of our unit in Melbourne a few years ago, scale a wall, cross Clayton Road and go to the local police station where he reported to the police that there was this illegal, strange unit where people seemed to be dying in large numbers. In fact, it was the hospice palliative care unit at McCulloch House at Monash Medical Centre. But maybe if we look at our practice in the light of your talk, then perhaps he had a point, that we are serial offenders. We have about 350 deaths a year in our small Hobart unit, our 10-bed unit, a death every calendar day. None of them would have artificial hydration and alimentation. Most of them would be sedated, and I think from a spiritual existential point of view at least, we're coming to question why we're using so much, having to use so much sedation to retain comfort and dignity. And you're perfectly entitled, you need to be the grit in the oyster as an academic lawyer working in the field. So that's welcome, and I think your analysis, like Jocelyn's yesterday, is very pertinent. But I wonder whether a different approach is to go back to the re-BWV case in the Supreme Court of Victoria 2003, where Justice Morris held that artificial hydration and alimentation was medical treatment like any other. Therefore, its deployment was subject to the same conditions as any other medical treatment, and the main condition is that it confers benefit on the patient. And I would contend that if you're dying, it confers no benefit and therefore should not be regarded as a standard treatment, and therefore eschewing it would not be a potentially even legally defined offence. So I think the way around this is perhaps to explore, as the Consent to Medical Treatment and Palliative Care Act in 1995 in South Australia did, a terminal phase of a terminal illness. And within that imminently dying framework, to recognise that artificial hydration and alimentation would represent obstruction of the dying process. And then I think we can have a good discussion about this that would be really applicable in the real world, because the position of legal clarification that both you and Jocelyn see as a sort of standardising, codifying remedy might have the potential, as we showed in a paper that Lindy and Ben and I wrote about double effect, that when you try and codify it, in fact, it doesn't go very well, and you end up in a more difficult position than you were beforehand.
I think it depends on what you're trying to codify, actually, I should say, and I think, I'm not sure I would use the word codification, but I think what I'm thinking of, and I won't speak for Jocelyn, but what I'm thinking of is something that encapsulates a series of values which are obvious and clear and widely accepted. I'm sure you're not a serial offender. You look far too nice to be a serial offender.
As a lawyer, you should know that's a very dangerous assumption, but anyway.
Yeah. That's okay. I'm only an academic lawyer. It doesn't really matter.
I'm sure Dr. Bodkin Adams looked quite charming in the doctor.
But your question about the court's approach to assisted nutrition hydration is also common in the United Kingdom, as you'll know from the Anthony Bland case. In order to reach the conclusion that they wanted to reach, and this is me being rude about lawyers now, you'll be glad to hear, but it's quite clear that the House of Lords in that case, a man in persistent vegetative state as it was then called, decided that, or some of them decided that the justification for allowing him to die by removing the nutrition and hydration was that this was medical treatment. Not everybody was happy, not all of the judges were happy with that at all, because it seemed counterintuitive to some of them that that would be the case. But by dint of, I think, something like 6 different routes, the judges in the House of Lords managed to say it was lawful to remove nutrition and hydration. So although the odd court has said this and said this is definitely medical treatment, you don't want to bet all of your pension on that being something that is sustainable in the face of a good and competent argument against it, nor in fact should we necessarily be comfortable with it, because it opens doors to all sorts of options that we may not necessarily want to see. So I get where you're coming from, but I still don't think that allowing judges to make these kinds of decisions necessarily makes them right, and it doesn't make them invulnerable to challenge either.
But Tony Bland wasn't dying.
No, that's the point, and that was why making this decision that this was medical treatment was peculiar to some of us, because he could have lived forever. I mean, as far as I'm aware, the longest ever survival in PVS was, what, 36 years? He could have survived forever, if you can call that living. But in order to reach the conclusion that they could let him die, in fact, he was killed, I would argue, but that's the act and emission distinction again, they had to categorize assisted nutrition and hydration as medical treatment. So it isn't an unchallengeable position, even in cases where people are dying.